We're now going to have the third panelist, Ms. Kiran Matti, and she is going to come and share with us.
Madam Chairperson, for today's proceedings, Ms. Henry, Honorable Minister of Natural Resources, Mr. Rafael Trotman, Honorable Ambassador of Mexico, esteemed members of the panel, members of the University of Guyana Administration, members of the audience, members of the media, both present here today and those virtually participating. Good evening, and thank you for inviting me to be part of this distinguished panel. As an alumna, I'm overtly enthused to be able to connect to the University of Guyana, both metaphorically and literally, as through this virtual platform, issues such as the globalization of oil and gas evolve from its nascent state to actual reality. A forum such as this allows us to be able to talk, no pun intended, so I'd like to thank UG for coordinating today's efforts and today's proceedings. As I have noted, I am an alumna of UG, having graduated from the law program in 2009, completing my LEC in 2011, and finally my LLM in oil and gas law in 2015. It is, however, these years in between that have provided the framework for my presentation this evening, as I'll be discussing the theme, preparing for oil and gas through legal training. What I would like to clarify, though, at the outset is I do not hold myself to be an expert in this field, but I do believe because of the specificity in my theme, which is referring to that of legal training, I may have some amount of locus standi. But on a lighter note, I believe that I've proven that I've had legal training by immediately providing a disclaimer at the beginning of my presentation. Now, throughout the course of this presentation, there are three major areas that I want to be able to touch on, and I want to expand on as it relates to that of legal training. That of lex petrolia, principle of permanent sovereignty, and the relationship between oil and gas and that of the green economy. What's common among these areas is the legal underpinning to which we as a Guyanese populace may attach our identity, such that there's a balance between exploration, disposition, and development of our own natural resources. And Minister noted that he's from New Amsterdam. My mom is actually from Berbice, and so I like to hold myself so I'll also refer to this Tain and Turkeyen Tain. Now, as I mentioned earlier, I read for my LLM in oil and gas law, and it was always a running joke that the title of our LLM program was really a misnomer, because the concept of oil and gas law was so utterly generic that while the term may really encapsulate the framework that regulates the operations of the industry, the development of a lex petrolia would always be a work in progress, considering that oil and gas activities rely heavily on various disciplines of law, including but not limited to international law, company law, there's contract law, human rights law, environmental law, and of course dispute resolution. Therefore, while the oil and gas industry remains dominated by technical and scientific risks and research, that added composition of law allows for the erosion of some of that risk through the allocation of liability among all involved parties. Those therefore considering a future in the industry must therefore recognize that legal training in oil and gas is a specialization cocooned by the vocabulary and decisions that are constantly developed into lex petrolia. Within the scope of preparing for oil and gas, this therefore translates to an appreciation of law as being dynamic within the industry and not just relying on precedent or statute to equate risk and reward. Rather, one's legal training as applied to oil and gas needs to be based on merging yet differentiating the relationship between the state, the people, the international oil companies, and of utmost importance, the law of the land embodied and executed within and by our Constitution. Now, it's really that supreme law that shapes the concept of permanent sovereignty over natural resources through the principle of resource nationalism. Now, what that really means, and implicit in that doctrine, is that the state's right to regulate and exercise authority over foreign investment within its national jurisdiction in accordance with the laws and in conformity with national objectives and priorities. Therefore, for Guyana, as an emerging economy, one needs to be able to appreciate the ownership of our own resources while encouraging an international economic order and redevelopment of that North-South relationship, or in our case even the South-South relationship, due to the nature of our own geopolitics. The question may be raised, how then does permanent sovereignty really relate to one's legal training and preparing for oil and gas? And I'll explain this in a few points. A, the doctrine reiterates sovereignty over profit and therefore constitutional supremacy. B, it reiterates equity in assuring foreign investments and entering into agreements in good faith. And C, there's a recognition that the sovereignty is an overarching concept and there must be a move beyond traditional commercial relationships. Legal training must therefore account for the needs of the energy industry and the perspectives of both the host country discovering the oil and the companies exploring for oil. It's therefore not enough to find an immediate solution through the law, but it is really what is viable and what is sustainable. And I want to stress on that word sustainable, and I use it as a segue into my third area, which is the relationship between oil and gas and green energy. Now, this particular area is perhaps the most practical application in my legal training, as I actually work with the Guyana Energy Agency, and we hold a mandate for research and development into alternative and renewable sources of energy. But before pursuing my studies in oil and gas, I worked in RE for about 2 years. And it wasn't a decision because it was really taking on a bandwagonist approach, but for me to truly understand the energy industry as an attorney, I needed to develop a holistic understanding of the oil and gas resources. Essentially, it was to reconcile the benefits of our geography and territoriality with that of sustainable development. I would further emphasize that from the standpoint of sustainability, it's not just about the existence of these resources, but there must be the method of harnessing these resources, state policies, and legislative frameworks to support sustainability. In Guyana, as we all know, and we would have heard from Mr. Alexander regarding our national and natural environmental heritage, is really evidenced through forestry, rice, sugar, water resources, and that supports the vast potential for the exploitation of renewable energy. In fact, His Excellency Brigadier David Granger, in the signing of the Paris Agreement in 2015, mandated the movement towards 100% renewable power supplied by 2025, conditional on appropriate support and adequate resources. Our national move towards a green economy does not, however, negate our continued exploration for oil and gas resources, as Minister would have noted. There will be oil by 2020. Rather, the infusion of renewable energy can only serve to liberalize our energy markets and create that level of self-dependency to buttress our own sovereignty. Therefore, for legal training, the lesson in preparing for oil and gas is A, recognizing that oil and gas is only a piece of the puzzle. There must be complementary interdependence to achieve sustainability, particularly if one adheres to the theory of peak oil. And B, oil and gas legislation does not make one prepared for oil. Minister would have spoken to the Sovereign Wealth Fund and the new pieces of legislation. But of course, as he would have mentioned as well, there must be the considerations of moving outside of those institutional frameworks to lend support to agencies and entities through proper training and capacity building so that our legal world is not just pen to paper. Legal training in preparing for oil and gas means improvement, analysis, and developing efficiency in supporting areas as well. So for example, environmental and marine training, developing health and safety regulations, reviewing investment procedures based on the legislation so that new companies who are looking to invest are not excluded, nor is the process convoluted, and of course, supporting green initiatives that can be applied in corporate environments through social responsibility programs. Legal training does not need to be limited to the phrase oil and gas. Legal training means preparing to support the energy industry as a whole. So really just to bring this all into perspective based on the areas that I would have referenced, I wanted to just link these principles into one example, for example, through the production sharing agreement. Now, a PSA is really a typical contract. One's legal training will really dictate the review of each clause to ensure core requirements. That is contractual, so we look for transparency, for good faith, for reiterating the protection of our resources through sovereignty. But in the oil and gas industry, our legal training needs to go beyond that, just to understand the essence of the relationships between parties through our own jurisprudence. And that ultimately defines the legality of the PSA and provides a middle ground between governance by contract and governance of contract through regulatory relationships. Now, having said that, regulatory can really work in terms of a dual translation, and it really emphasizes a sociological perspective in light of attaining social cohesion to achieve the maximum interests of society. So therefore, we can adopt it to look to overarching legislative structure, as I would have mentioned, but we can also look to it as looking to incorporating management and control mechanisms, such as ministries, sector agencies, and oversight committees. Therefore, a regulatory relationship illustrates law as a social phenomenon shaping society. But conversely, that contractual relationship may be underscored by the economic school, so that the agreement itself aims to maximize party satisfaction by directly reflecting the interests of parties through dispute resolution, considerations for taxation, profit, and incentives. So by enshrining a modified fiscal regime within contract, parties are able to operate within that created marketplace to achieve efficiency. And really, the common thread between regulatory and contractual relationship lies in history, thus reflecting the culture of the people. And in Guyana, this is really by which we are defined. So in conclusion, the way one can truly prepare for oil and gas is to establish sound legal training and contextual thinking through understanding the core principles of legal disciplines, while ensuring that there is application to the situation at hand. And I stress on that, applying it to our current circumstances. As noted previously, it's not just about precedent, but it is a relationship among law, energy, governance, and natural resources. Now, law through contract abides by that phrase, and I'll stick in a little bit of Latin here just to prove that I have that legal training, which is pactus sunt servanda, and that really translates to certainty of contract. But legal training in oil and gas teaches one to prepare for those situations, rebus sic stantibus, which literally means non-application due to a change in circumstances. So it is therefore the attorney who must determine how to balance those relationships through contract and regulate a kinetic industry to ensure maximization of resources for a green economic recovery. Thank you very much for your attention.
Thank you very much. And she is a UG alumna. Please put your hands together. And I know for me what I got from her is that we must look at the laws, the contract, and so on clearly and make sure that these things belong to Guyana and that we owe them and that we are smart. Right? That's what I got from it. You will ask the intelligent question.